Thank you.
Anna Warner, NAMI Sacramento, and I'm on the Sacramento County Ad Hoc Committee that's identifying needs in Sacramento County right now, and also a family member of more than one person with a mental illness in very strong support.
Thank you. Any others in support? All right. Opposition may come forward, and members with questions, let's take the questions after support and opposition, and then I'd ask the members if they wish to direct their question to a particular witness, we'll have that witness at the table, if that's okay. Same rules, 3 in opposition at 3 minutes each. I'll do my best to apply the rules fairly and whatever. My only job. Okay, who's first in opposition?
Madam Chair, Carl London on behalf of the California Psychological Association, we are opposed to the bill. I don't think that, and I'll start by saying that I don't think we disagree at all with the problem that Ms. Thompson describes. I think everybody here, I bet, is on the same page in terms of what the problem is. I think that we have a fundamental disagreement over how we go about solving that problem. Our thought is that the people out on the street are largely symptomatic of the lack of resources that we've had in mental health programs throughout the state for 30 years. And that's why we're supporting bills like Mr. Steinberg's AB 34 of last year and AB 2034 of this year that expands the community mental health services model and program. We believe that's the more appropriate way to address the problems. And once we have a system that's at least decently financed, we'll find out whether further problems exist or not in terms of the availability of services for these people. The second issue that I'd raise is that we have, and this speaks more to the specifics of the bill, we do appreciate at least one of the amendments that Ms. Thompson made in the Health Committee. There is a secondary issue that's raised by the language of the bill right now, and I've talked to some members about that, and that is on page 11. There's an anomaly in law right now that exists whereby if a psychologist admits a patient on a 5150 to a hospital and they're certified for a 5250 and they continue to treat that patient and direct their care, they can discharge that patient at the end of the 14-day certification review process, or the 14-day period. This bill expands that period now to 28 days. The law as it exists right now and is continued to be proposed in this bill would suggest that the psychologist, despite the fact that it's their patient, would not be able to make the decision to discharge that patient early. We think that the expansion from the 14 to 28 days will only aggravate those situations where patients are held inappropriately so, and here's the reason why. In county mental health, it is getting increasingly difficult to find psychiatrists to work in these programs. That means you literally have to go out and find a psychiatrist to sign a signature paper to let this patient out early. That is not easy to do. That means your patient's going to sit there maybe another day or two. When you do find them, they're typically not somebody who's had a history with a patient or seen that patient, and they either are forced to rely on your word or go through the re-examination process of that patient in total and therefore make a decision. Not surprisingly, in that situation, they end up becoming very conservative and choose more often than not to not let the patient out. We think that the expansion of the 14 to 28 days in this bill aggravates that problem. We'd like to see that change. We've suggested either that the bill go back to the 14-day existing law, in which case we wouldn't hassle Ms. Thompson because it wasn't a problem she created. But if she does go to 28 days, we'd like to see that corrected, at least as it applies to our patients that we admit into 5150 holds. As another issue, we disagree with the changing of the definition of grave disability. In law right now, you can be admitted to a 5150.
Mr. London, but
yes.
that was your 3 minutes. So if there's any other witness that will present the against the question of the definition of grave disability, I don't know. If not, I think we'll come back and ask you about that if we can.
Madam Chair.
All right. Next witness.
My name is Kira Kazantzis. I'm representing the CARES Coalition. I'm an attorney, and I am the co-author of a 30-page legal and policy analysis that I suspect you might not have had at the top of your bedside reading last night, but nonetheless, I'm actually not going to reiterate all the numerous constitutional and other legal concerns I have with this bill, but would be happy to take technical questions after my testimony. The reason for this is not as a favor to you all, but because I think we tend to get lost in the technicalities and the gray areas of this very important issue, and we don't look at the big picture. I think it's helpful in this situation to look at the things we know and the things that we don't know, and to kind of telescope out and look at those. What do we know? We know that the system is drastically underfunded. And as a result of that underfunding, we know that people wait in line to get voluntary mental health services. We also know that as a result of that underfunding, that the inpatient length of stay after managed care was drastically reduced and now is at an average of 5 days, which is significantly less than the current 14-day certification and voluntary certification. We also know that mental health consumers continue to face enormous stigma based primarily on an unsubstantiated fear of violence. These are the problems we know exist. Do we know anything about solutions? We do. We know that voluntary psychosocial rehab works. We know that aggressive outreach works. We know that self-help works. And thanks to the Surgeon General, these solutions and the statistical support in support of them are well documented in his report. Now, what do we not know? Look to AB 1800, because I think AB 1800 involves and is rife with uncertainties. Specifically, anecdotal stories of inadequacies of the LPS Act have been presented. But if you look to the Russell study of 1986, it shows that a substantial variation in the implementation of the LPS exists among counties. 2, that shortages of involuntary treatment distort the implementation of involuntary treatment laws. 3, that the data was inadequate to understand and to accurately assess the current use of the involuntary treatment laws. The suggestion of the Russell study was, let's keep better data, let's improve our monitoring, and let's train people who implement the LPS Act to fix these problems. None of these things were ever done. Uncertainties. And the effect of a radical expansion of the grave disability standard is wholly unknown. This bill would allow the involuntary commitment of anyone who is at risk of psychiatric harm. And I would be happy to explain what I think that means under current tort law to you later. But a lesser broadening of a commitment standard in Washington state resulted in their system of care, mental health care, being overwhelmed. There was a very good statistical study done of the Washington commitment standard broadening, and it showed that the resources were so overwhelmed that there was very little quality of care, even in inpatient involuntary commitment, and there was virtually no voluntary commitment because the expensive mental health involuntary system outpaced the voluntary system. And the last thing I would say with regard to the proposed outpatient commitment scheme is that it is wholly unproven. There is no statistically significant study that shows that involuntary outpatient commitment is any more effective. And the Bellevue study shows, in fact, that it is no more effective than high-quality outpatient voluntary treatment. I would ask you which way the California state would like to go. Towards a solution we know, for problems we know, or to address in fear a problem that is speculative with a solution that is unproven. I hope you pick the former. Thank you.
Thank you. The third witness, please. Please press the button so the mic works.
My name is Sally Zinman. I'm the Executive Director of the California Network of Mental Health Clients. I want to clearly state how the clients across the state oppose this bill and this concept of expanding forced treatment and outpatient commitment. It's really across the country. They are, in fact, outraged that a bill like this would even be proposed because basically We were put out in the streets. We were not given any services. No services followed us, and now we are being blamed for the lack of services. There's a problem in the system when they're blaming us for that lack. We're being held non-compliant to non-existing services. I also want you to think in terms of this year and what's happening in mental health and the opportunities we have to build a really good voluntary mental health system, that we should work on issues that we can find consensus. We should find bills that unify us, not bills that divide us. And this particular issue not only divides the whole mental health community, it is dividing families, tearing families apart, and will continue to. As Kira said, it is very clear that voluntary enhanced services work. They have not been available. They have not been tried. I mean, try them first and then see if there's a problem. Housing, social services, income supports, the variety of holistically dealing with, including medication, the issues that mental health clients face and need are not there, and that's what the mental health system should be building at this time. Self-help services, not forcing us to services that don't exist. Coercion has, there are studies showing that coercion creates noncompliance. Coercion is not the solution to noncompliance. Coercion literally has created it. There are many people that you might consider have no insight on the street. The fact is they have been there and done that, and they don't want to go back because of their experience with forced treatment, with coercion, with 5-point restraints, with not having control over their own life or not being able to have decision-making in their own treatment. There's a study called the Wellbeing Project, supported by the California Department of Mental Health, that said that 55% of the people interviewed who had been involuntarily treated would not go near voluntary treatment of any kind in the future. I want to say that this roller coaster to expand forced treatment is based on certain myths that are just not true, and I don't know how you stomp out those myths. One is the violent mental patient. That has been exasperated specifically to advance this agenda to expand forced treatment. People pushing this agenda to expand forced treatment have taken the issue out of mental health and made it a crime issue. It is not a crime issue. Statistics, research says that people with mental disabilities are no more violent than the comparable person in the community. Another myth is the myth of the incompetent mental patient. We gave you a fact sheet that says the link between mental illness and decision-making may not be what you think it is. In fact, most of us are competent to make decisions, and research bears that out. The myth that medication works all the time, the new wonder drugs have no side effects. The fact is it works maybe 50% of the time, so you would forcibly medicate 100% of the people for 50% of the time.
Ms. Inman, we'd ask you to conclude,
okay.
if you could.
It's hard to describe what taking somebody's freedom away means. Maybe it's because you have not experienced it. Being in a locked place where you don't have the keys, of being in a security room where you can't get out. I was in a position where I couldn't go to the bathroom unless someone decided it was time and that was okay, that it was somebody else's decision. Being in 5-point restraints where you are totally re-traumatized. Freedom is a fundamental organizing principle of our society, and based really on these myths, people are thinking of taking it away from only one group of people, people with mental disabilities. There is no reason why the mental health system, that we should not be able to have services that are based on force, based on freedom and choice, and if we did, we would voluntarily seek them. I hear more stories of people seeking voluntary services and being turned away than the reverse.
Thank you. Thank you very much. Thank you to the three witnesses. Thank you. That's enough now. That's the last cheer or boo or any kind of anything I want to hear here. I understand that there are some emotions on both sides, but I'd appreciate total decorum in the room. Thank you. Others in opposition to the bill may come to the mic. State your name and affiliation only, please. I know there are many more stories Trust me, we've read a lot of the letters and the stories. We don't need to hear them again here. Others in opposition, please.
Wendy Taylor for the California Attorneys for Criminal Justice. We oppose this measure.
Thank you.
Rusty Salix, California Council of Community Mental Health Agencies. We are opposed to the bill in its current form unless it's amended to reflect the principles of Mr. Steinberg's legislation, which we sponsored.
Thank you very much.
Paul Garowitz with Protection and Advocacy Incorporated, opposed to the bill.
Thank you.
Kim Lewis with the California Association of Mental Health Patients' Rights Advocates, opposed to the bill.
Thank you.
Jack Feldman, and I'd like to ask, what is the purpose of a temporary conservator?
Thank
Ted
you. We'll note the question. Go ahead.
Ted Shapasinski, Directing Attorney of Mental Health Consumer Concerns in Concord. If this bill had been law 20 years ago, it would have been used to lock up the chair of this committee, and for that and many other reasons, I oppose this bill.
States facts, not in evidence, about whether or not I've been locked up.
Hi, Elaine DeRush, Los Angeles Client Coalition, Los Angeles County Client Coalition, in opposition to this bill.
Thank you.
I'm Carol Patterson. I'm a survivor of involuntary treatment, and also I work for Independent Living Resource Center in San Francisco, which is opposed to this bill. Also, the California Federation of Independent Living Centers is opposed to this bill, and I am opposed to this bill very strongly.
Thank you very much.
Bill Compton, Project Return to Next Step, which is the largest self-help organization in the state. We're opposed to the bill.
Thank you.
Jerry Esposito, California Society for Clinical Social Work, strongly opposed to this bill.
Thank you.
BJ North, CSS, Community Organizers, and we're strongly opposed to this bill.
Thank you.
I'm also a survivor.
San Jose?
Thank you.
Santa Cruz.
Oh, Santa Cruz.
Thank you. Next, go ahead.
Karma Winfrey Hayes, San Francisco Depressive and Manic Depressive Association, and we are strongly opposed to this bill.
Thank you.
My name is Dave Hosseini. I'm a family member and a consumer representing the California Association of Social Rehab Agencies, 38 mental health agencies around the state strongly opposed to this bill.
Thank you.
I'm Vicki Weaselthier. I'm from the great state of Missouri. We have a bill like this, and it doesn't work. And I'm also the executive director of MedNation.
Thank you.
Janie Anker, psychiatric survivor, president of Mental Health Consumer Concerns. We are strongly opposed to this bill.
Thank you.
Hi, I'm Emily McClarty, and I work for a psychosocial rehab club in San Diego. And we're for the rights of the mentally ill. And it's very important for all of you because we're all a little mentally ill.
Thank you.
My name is Douglas Hammond, and I'm representing the Community Center in Concord, and I'm a consumer, and we're strongly opposed to this bill.
Thank you.
My name is Arnold Cruz. I suffer from schizophrenia, paranoia, and I support the bill because I'm homeless. They just kicked me out of the hospital.
Thank you. Anyone else in opposition to the bill? All right. We'll have questions from members or any whatever members want to talk about, and all witnesses are available. Those who testified in favor and those who testified against are available for questions. I have a question from Mr. Steinberg.
I'd like to ask a couple of questions of Judge Szabo, if I might.
Judge Szabo, if you'd come back
Just
to the
asked him
table,
to come
please.
back.
Thank you.
Call you if they question me.
Yes.
Ms. Kazantzis, there's plenty of chairs if you want to stay seated at the table. That's fine. Go ahead, Mr. Steinberg.
Judge, I appreciate your work and appreciate your efforts in this area.
And yours.
Thank you. Well, we talked about the revolving door. You talked about the revolving door. And I'm wondering, in your experience, what percentage of the people you have seen through your mental health court have been offered comprehensive services following discharge from 5150?
Insofar as I only see the people who've been discharged after, or who are on a 5250 hold or a later hold. Insofar as I am aware,
there's very little in the way of actual offering of services because there are very few services to offer that are consistent or reliable or available.
And the same question on the front end. What percentage have been offered as comprehensive services prior to the 5150 that from what you can see?
Very few. I mean, the availability of community-based services is so sporadic. If a person, for example, has a co-occurring diagnosis, is a drug abuser or addict and has severe mental illness, those people are excluded completely from either drug treatment or mental health care. Each agency feels it's the other's responsibility.
Let me ask you about how hearing officers and judges have interpreted the law, because one of the arguments made is that if the law were interpreted correctly as it was intended, we might be able to get more people into involuntary treatment who meet the criteria. Section 5008.2 of the Act, as the analysis reflects, expressly allows a hearing officer, judge, or jury to consider information about the historical course of the person's mental disorder. As I read Assemblymember Thompson's effort to change the grave disabilities statute is in part an effort to allow hearing officers to consider historical information. So you get the whole picture here. Is the person likely to deteriorate to even a worse point? Is 5008.2 generally considered? If so, how so? If not, why not?
First of all, judges are not especially well trained in applying the mental health laws of California. Los Angeles is one of the few counties that dedicates its a court or a courthouse to dealing with mental health cases, in the LPS Act in particular. Each year, the California Center for Judicial Education and Research has a probate and mental health institute for judges who voluntarily can come and learn about mental health law for approximately an hour or an hour and a half, whatever time they give me to teach. And it's begrudgingly given because people are interested in probate, not in mental health. It's in the application of 5008.2 is inconsistent depending upon the judge. Many judges resent being assigned to hear mental health cases. It's done on a rotational basis in many counties. The judges may hear one case sporadically, through a year. There's no accountability by agencies to a particular mental health judge, as there is in LA County.
Let me then follow up. If judges and hearing officers were adequately trained in the meaning of 5008.2 in the entire Act, and the system was fixed, as you've described, part of the dysfunctional system which we know exists, but if the right training occurred, what would be the result of applying the current law in terms of increasing involuntary commitment?
I really don't think that there would be a substantial change in current law if prior history were really taken into account.
Say that again. If prior history were taken into account,
if the history of the patient, noncompliance with medication on prior releases, for example, were taken into account, I don't foresee that there would be a major change in the numbers of involuntary patients admitted, nor a major change in the law. I don't think the current additional language really changes very much. It just makes clear what judges very often overlook, and that is passive neglect on a patient's part. Someone who is diabetic and has such a high sugar level in the blood that they're likely to go into a coma, and yet denies that they have diabetes and refuses to accept treatment, that kind of individual would be addressed.
I guess my question is, the correct interpretation of the current law could lead to the same result.
Yes, it could, and it should, but it doesn't. And it certainly doesn't consistently, depending on the length of the chancellor's foot.
Okay. I have some comments I want to make. I can hold them until after the questions, but I want to make sure that I have the opportunity to make some comments.
If you go like this, I always follow.
Thank you.
All right.
I'm sure.
Ms. Bates is next.
Thank you.
I supported the bill in the Health Committee, Ms. Thompson, and at that time I did raise some of the concerns I have. I was a social worker with the County of Los Angeles. I administered the disabled program at the time that the original LPS came in, and saw the ravages over time of the revolving door problem that has been spoken to in that committee, Health Committee, and also here. I remain concerned with the bill, however, on the front of the psychologist, the role of the psychologist. They are certainly a very respected member of the health community. They are working in this arena as diligently as all the care providers, and yet they are left out. And I see them being probably a safety net in terms of the length of the commitment. If they are an attending physician, they would be able to confer in terms of the placement and the need of that extended placement or the need for release, and should be included. And to that end, I'd like to propose an amendment which would deal with their addition, and it's on page 11, the sections 52, 57. There are three different areas or sentences in there that you could easily add psychologist and not change the intent of the bill and what you are, and what I certainly support you are doing with it. So I'd like to propose that.
Mr. London, could you come forward to the table? All right. Ms. Bates is moving an amendment.
It's current law.
Generally, as mentioned by Mr. London, which had to do with, I think, the ability to release. And I know that Mr. London came prepared with these amendments. Has Ms. Thompson seen them?
No, she has not.
Well, that would be a good start.
I would like to also speak to the issue.
I understand that. You'll be, of course, given the opportunity to.
Thank you.
Let's have a copy of the proposed amendment as Ms. Bates has moved and Mr. Ackerman has seconded the addition of the words "or psychologist" at 4 places on page 11. In 5250 or 5270.15. And it's under section 5257 as it appears in the bill.
Mr. London and I had a discussion at the first hearing on this bill when he initially raised this issue. This issue is in litigation. There is a court case in Fresno about who it is, within whose scope of practice a patient can be discharged from a hospital. At that time, I said, and I maintain and will resist this amendment, this is not a bill about scope of practice. And if Mr. London's testimony is that fine, then leave it at 14 days rather than 28, that I'll go that route, because I do not wish to have this bill become a scope of practice bill, either for psychologists or psychiatrists or social workers or anyone else. That topic is being litigated in the courts in California, and at some point there'll be a decision, and then there'll be a decision for this legislature to make.
So the author has indicated that the concern that gave rise to the proposal of the amendment by Mr. London, which was the expansion from 14 days, that her preference would be that we not force an amendment on her that involves scope of practice, but rather allow her to amend the bill back to 14 days, thus vitiating the need presented by Mr. London for the amendment. Would you, Ms. Bates, then withdraw your amendment if the author amends in that manner?
I would like to hear Mr. London's response, and, again, I do not understand the scope of practice argument. If you have a psychologist that can duly, by law, commit someone, and that is the person responsible for that person committed care, why that person is then removed from the role of attending physician and must subordinate perhaps years of work with that patient just let me finish on that, to a new attending physician who may only have a printed record. And I'd like Mr. Linden to answer the question regarding the litigation, then go back to you, Ms. Thompson. And again, I do support the bill.
Mr. London, and then I know an additional witness that may wish to speak on Ms. Thompson's point.
Excuse me. Madam Chair, we think that the issue should be addressed either way. However, having said that, we will, as we had talked with Ms. Thompson about earlier, acknowledge that the 28-day change, the change from 14 to 28 days, did draw further concern from our members and make this an issue in her bill. We will stand by our word that we gave her if she goes back to the 14-day process where there's the second hearing for another 14 days, and we will stick by our word on that. I think that's only fair. However, having said that, I will mention just briefly on the litigation in Fresno. Our understanding is the only reason there is litigation in Fresno right now is because of this very law that exists on the books today. And it is a problem because of the exact situation we described. There's a psychologist who has let a patient out. Probably shouldn't have done it under the way the law is written, but again, it was the person's patient, and they should have been authorized to do it. And so we would say that we may perhaps not revisit it in this bill given our commitment to Ms. Thompson, but we may bring the issue back again because we think it is one that merits review.
Then I would withdraw my amendment.
All right, and is the second withdrawn? All right, then there is no proposed amendment.
I'm sorry, Madam, and that the bill will go back to reflect
days.
where there's the 14-day and then the hearing as it is an existing law?
I'm looking to my legal counsel.
And he's nodding. Okay, we'll accept that as an author's amendment. Thank you, and
thank you very much
for, we'll essentially the scope of practice issue, which is in litigation, may be revisited, but it will not be now an issue for this bill. Okay, other questions or comments on the bill?
Yes, Madam Chair. To answer Assemblymember Bates' question about the scope of practice issue and the legislative history, the CMA filed a brief in that case, an amicus brief that laid out the legislative history of this. At one time, psychologists did have this power. The legislature took it away as a result of a rash of suicides from prematurely released people. They have introduced at least one bill, perhaps two, to restore that, and it was rejected by the Assembly a number of years ago. And I don't think there's been another bill since. So there is a legislative history. This is not an accident.
Okay. However, we'll accept the amendment without prejudice to the continuing conversation about
so that we
scope
can
of practice.
continue to talk about scope of practice.
Continue
issues.
not to talk about scope of practice.
Not in this bill.
Other questions or comments? Mr. Ackerman and then Ms. Aroner. In alphabetical order, clearly.
Good. Yes, Ms. Thompson, I had two major concerns from a lot of people I heard from, and you've already addressed one, the 14 to 28 days, so that one's taken care of. The other one is the expansion of the definition of gravely disabled, and I'd like to hear additional testimony both in support and opposition of that particular recommendation.
Why don't I let the judge answer that first?
I've now learned how to press the button.
Good.
As I said earlier, I don't believe that the additional language defining grave disability does anything other than underscore what judges should be considering as grave disability in any event. That is a person who, because of mental disorder, is impaired to such a degree that the person does not recognize the need to take appropriate steps to address a medical condition which could be life-threatening. That was one of the concerns that had prompted the change in language. The person who's homeless, who has a gangrene in his foot, who has no ability to recognize or obtain medical care for that condition, and the danger, for example, of septicemia and death as a result of the neglect of that condition. On the psychiatric harm aspect of the case, of the situation, the concern was of family members and others who had a family member living with them who had stopped taking medication and who was decompensating, and the idea of expanding the notion of psychiatric harm was to enable the hospitalization of that individual before the person became so out of control that the person became imminently dangerous to self or to others, or unable to provide food, clothing, and shelter. That may be somewhat an expansion, but in my practice as a judge, I have considered a person gravely disabled under similar circumstances. So I don't think, at least from my point of view, from my county, which handles a large number of mental health cases, that is an expansion of the definition of grave disability.
Could also hear from one of the opposition witnesses.
I believe, yes, anyone you wish to indicate a disagreement with the judge's interpretation of this
Yes, and
section.
with due respect to Judge Szabo, the examples he gave are actually all covered under current law. A person who's homeless, a person who has a gangrenous foot, a person who's suffering a life-threatening illness and will not seek treatment, a person who will not seek medical care because of their mental disorder, and a person who is dangerous to themselves in some way. All these examples are covered by current law under the grave disability standard. The grave disability standard currently provides that if a person fails to provide the basic necessities of life, and that includes food, clothing, and shelter, but could include other things, is holdable under current law if that is a result of a mental disorder. And it has to be, basically the constitutional law, and this is from the United States Supreme Court, O'Connor versus Donaldson, is that no one can be committed because of their mental disorder simply because they have a mental disorder, but only because they are a danger to themselves or to others. And the grave disability standard is a element of danger to self. And so
let me interrupt for a second, if I may. The concern, I think, that's expressed in opposition to this particular definition would stem from, I guess, that section on page 7, and I could be wrong, but under subparagraph A at line 16, we're now adding psychiatric harm.
Right.
Isn't that correct?
So now it would say that a person could be committed if they present an acute risk of physical or psychiatric harm in the absence of treatment. Frankly, I've never, and maybe this is a shortcoming in myself, but I have never seen a commitment standard that looks like that. So I don't know exactly what it means, and that's my fear. But I can tell you that in tort law, psychiatric and physical harm can range from depression, suicidality, to sleeplessness and other symptoms of anxiety. I don't think we want to be committing people for that. We have to have a standard that shows that the harm is real and it's substantial. This standard does not cut it by an order of magnitude. And the case law in California is crystal clear. You cannot use a need for treatment standard. You have to have current harm, facing current harm, and you have to have substantial harm. Notwithstanding any case in Washington State, that is not the law in California.
I think we get it. Mr. Ackerman, does that answer your question, pro and con? Okay, Ms. Aroner.
Could I just add a PS to this testimony?
The author can always add.
Thank you. In Connor versus Donaldson, which was the U.S. Supreme Court decision having to do with the conflict that exists inherently between the police powers of the state, which then allow a state to make a determination about involuntary commitment, and the parents' patriae power of the state in order and the duty that the state has to act as a responsible and caring parent in order to protect and help persons with legal disabilities who cannot act for themselves. And that's why I keep hoping, it's why we have this continued conflict and all of the emotion around it. But I think it's important to keep pointing out that there are two sides to this.
We get it. Ms. Aroner.
Thank you.
Mr. Ackerman, I think, got to the question for me, which is the definition of psychiatric harm, which there is none, and it certainly is one of my concerns in this bill. I thought maybe it was a legal term of art, but it is not, obviously. And that is a problem for me then, because getting back to Mr. Steinberg's questions, the introduction of history and the allowance of history, if that happened, then I don't think we need to expand the definition of gravely disabled. I think his question was very well pointed, in that in reality, in a hearing, very often history is not allowed because and the judge talked about the lack of training or whatever, and that's what Mr. Steinberg was getting at. If we could deal with the current system and make it work properly, would we need to do this, you're considering it a clarification. Some of us consider it an expansion because I'm not so sure it was necessary. But that's not the only. The bigger question for me is in the issue around the extension to 1 year for treatment, and this is on page 16 and 17. And this is where, and I don't know if this is current law. I mean, the 1 year I know is not current law, but it's the threshold, the evidence threshold that is of question to me. You're now going to expand the state's right to withhold somebody's liberty for 1 year, and you're going to do it on a threshold of clear and convincing evidence. I'm not a lawyer, Judge, so you need to explain to me. I do know that there are different thresholds. Is this the second or the third from the top? Because
second.
This is the second. Why wouldn't we?
I have to say that I don't support that part of the bill, and I think it's going to be changed, if I'm not mistaken, to proof beyond a reasonable doubt.
Well, it's not. You haven't taken it. It's not here. The bill's in print, and it doesn't have it. So you haven't taken it yet. Is someone going to take that? That's an incredibly low threshold that you got.
Reasonable doubt is the standard that we currently have. Reese-hearing is clear and convincing evidence. You're talking about the Reese-hearing or the 5300? The 1 year for demonstrated dangerousness.
This is 5300.
That's what I thought. That should be changed to beyond a reasonable doubt as the standard of proof, and that is the highest standard of proof.
Well,
that we did.
Well, we did, but we didn't do it on that page then.
Okay. We have a drafting issue.
It's also the
Okay, let's clarify then. We're talking about the top of page 17 in section 5300.
Right.
On further confinement after 28 days. When it can go to a year.
For demonstrated dangerousness, it should be proof beyond a reasonable doubt.
All right. So then if it is proved by, what is the appropriate language? If it is proved beyond a reasonable doubt?
No, Ms. Chavez tells me that they want to drop the reference to the standard completely. Current case law has held that proof beyond a reasonable doubt is required, and that would be the standard that would continue to be employed.
So why can't it be written into statute so that it's clear that everybody means that?
It's fine with me.
If you want to put that precedent in statute, but what we were trying to do was put the clear and convincing evidence precedent in statute.
I know.
And so if we want to reverse that, we just take that language out and you have case law that provides the precedent.
Or the legislature can provide it by just saying in statute what it is. Why wouldn't we want to do that? That way it's not debatable. Correct?
Correct.
Thank you. Okay, I think it needs to go in. That would be certainly be my suggestion.
Will be the same concern with regard to establishing conservatorships.
I just think when you're talking about withholding somebody's freedom for such a long period of time, that I got concerns around whether or not a commissioner should be doing that or only a judge should be doing that. I think that when you're upping legal standards like this, when you are doing something that's pushing the envelope on constitutional issues, considering my personal experience, right, and people have heard me testify to the personal experience publicly, to think that either of those commissioners would be making a decision on behalf of David as to whether or not he was going to be committed for a year, I have real questions regarding the competency of those decision makers. And so I want to be sure, I guess, that the consumer is so thoroughly protected at that point that, first of all, you have it to the highest degree in regards to what somebody has to prove. And second of all, that you're using a judge who hopefully is trained in these decisions. Because that's a little scary at this point. I know, it's a little scary, though, Assemblywoman Thompson, regarding that. Because there's nothing in the bill, all right? I mean, there's something in the bill that deals with training, but we're never going to, the adequacy of training when you have judges who don't want to deal with these issues anyway, they're not sexy issues. As the judge says, they were there for probate training, of all things. What's sexy about probate, Madam Chair, with all due respect? I don't have a clue. But, and that's why I'm not an attorney, probably.
Yeah, we think that everything's sexy.
I know. All right. So, anyway, but the next issue I want to raise, though, is the
wait. Let's one thing at a time.
Let's be sure we have an agreement on that.
All right. The request from Ms. Aroner is, if indeed what is meant is a standard of beyond a reasonable doubt, that we would feel more comfortable if it was stated in the statute rather than left to the whimsical nature of case law as it comes and goes. Does the author accept it as an author's amendment?
having a hard time with it because I'm not sure that after all of the discussion we've had, that this is the one thing that would hang this bill up. So it's kind of out of the blue for me. Judge is telling me it's not a problem.
Ms. Thompson,
I
I know
would
that
follow on his,
I know that it's
advice.
difficult. I've been in the same circumstance, mostly over in Senate committees, where I find them, really to come at me with a lot of amendments. But it's kind of like being pecked to death by ducks.
Mm-hmm.
There are a lot of concerns here about the bill, and each of the members may have a somewhat different concern, but they're pretty serious concerns raised.
I understand
in
that.
the analysis. The protection, if indeed this bill is going to move along, there's a general feeling that some of the protections do need to be stronger. There's a concern raised in the analysis about the ability of non-judicial officers to make these decisions on capacity, which is not the case in current law if you're going to put these hearings together. That concern, it's just a lowering of standard that I don't think hurts the bill.
Okay.
In terms of what you want to accomplish. Because the question about grave disability, for instance, which we just talked about, and the lack of definition of psychiatric harm is an issue. This is an issue about beyond a reasonable doubt. The ability of non-judicial officers to make capacity decisions is an issue. Maybe they're only one thing here and one thing there, but if we add them all together, I'm not certain what happens with the bill, and I know that the general issue is one that has to be addressed.
I appreciate the discussion, and if you want to have that amended in, that's fine.
Need to apply to conservatorship sections too.
All right, then beyond a reasonable doubt, which is the current legal standard, would appear then not only, I think, in the section in 5300, but in the conservatorship section as well.
On page 24.
On page 24.
Lines 35 and 36.
Right, where clear and convincing was deleted in the current bill in print, we would add beyond a reasonable doubt. So that same amendment taken in those two sections are accepted as an author's amendment.
May I inquire on that issue alone?
Ms. Jackson, on that issue.
On that issue alone, the issue of beyond a reasonable doubt is done in conjunction with grave disability. You have to define grave disability, and then you have to find that it exists beyond a reasonable doubt. Part of the problem is defining grave disability. We've just now tried to deal with that. You acknowledge that psychiatric harm is a term that no one's quite clear about. One of the concerns that I have heard,
one of the witnesses did. I haven't acknowledged that.
You did not acknowledge that, I'm sorry.
No.
Okay. No. The notion, however, of trying to define that term, I think, has been part of the problem and perhaps part of the frustration that some of us who have had the pleasure. Are you still on Front Street? Was it down in L.A.? You're
on San Fernando Road.
Yes, that beautiful area in Los Angeles where
tracks.
I had the occasion many years ago to do some of this work. The definition of grave disability is one that is so difficult, and I know a lot of families have been very frustrated by the fact that that definition is so oblique, that it can literally mean, as you indicated or someone previously stated, that if you can find your way to a tunnel and figure out to sleep there overnight, you are not gravely disabled. My concern is that we're now raising those standards again without filling in the meat of what is grave disability. And I think if we're going to require, and I support the notion of requiring a standard beyond a reasonable doubt for 5300, let's do something about that definition so that we all are understanding it, rather than having judges who, with all due respect, Judge, have no more right making this decision than a law clerk or a law student. I mean, let's face it.
Well, current grave disability is the inability to provide for food, clothing, or shelter, to be in imminent danger to self or others. That's the current definition.
Yes, but how is that defined? How is that?
That is the law.
That's the current law.
That's the current law. So you'll find various definitions in terms of the practice of the court all over the state.
That's my point, is that
and
the
that
practice
will be a problem, and it will continue to be a problem because this is the law. This is the current law. Even if we were to take out risk of physical or psychiatric harm.
My concern,
Other states have definitions which are equally perplexing.
My concern, though,
not-
is that in part of what I think is your purpose in this bill is to try to get some kind of definition that makes sense so that we don't have it being applied all across the board. Isn't that something that we should be focusing on? Not just that we have an existing standard that is defined by different courts in 100 different ways.
Instead of saying psychiatric harm, one could say psychiatric illness. That's defined, and there are definitions for that. But I'll
But
let
a
the
person
judge
is
deal
not
with
gravely
this.
disabled simply because they have a psychiatric illness.
Exactly.
All right. Now,
exactly. That's why we got to.
Okay, wait. Let's stop chasing our tail on this for a minute.
Thank you.
First of all, the beyond a reasonable doubt standard that we put in for the extension to 1 year has different standards, not gravely disabled. Okay, that's in that first section. For the conservatorship section, however, it does relate back to the definition of gravely disabled, in which case we're trying to prove beyond a reasonable doubt that a person presents an acute risk of psychiatric harm to himself without a definition of what that means. And I think the point is well taken. Now, this is the second committee for this bill, and people have shown some goodwill about attempting to do this as we go along. But, Ms. Thompson, I think it's really, really important that you hear that there's more than one person on the committee concerned about the lack of definition of psychiatric harm as an element, and a single element, sufficient to show that a person is gravely disabled. And I understand wanting to leave this to a great extent to judicial discretion. There's a lot of discomfort about that. And so I don't know, obviously we can't craft a definition here, but I think that there's sufficient concern that you're going to have to look at this.
I think that
if this goes anywhere.
I understand that. I understand that this is a major issue for people. The judge does have a suggestion. He had several of them as we worked on this language. So perhaps you'd hear what he had to say.
One might be, which I just wrote out. Excuse me. And I had offered some privately a few weeks ago, but I don't have my copy of the email with me. But what essentially I think what you could do is use language such as this. Substantial psychiatric harm means substantial deterioration in perception or judgment such that the person is unlikely to be able to function independently. That's about as close to a definition of psychiatric harm as I can come up with off the top of my head sitting here. But
Well, I don't know that any amendment is going to sway anyone one way or the other. I mean, I don't know whether that's something that people would like to see. Some language in the bill in order to support the bill. I'm not pushing one way or the other. But, you know, my job is try to figure out what the heck's going on among various committee members.
Madam Chair, may I make a brief suggestion?
Mr. London.
Yeah, we've had concern over this as well. And again, psychologists are in the law certification review hearing officers, so they did have concern that we expressed to Ms. Thompson about this. And I guess the concern they have is that this definition that's in the bill now is not something that is very objective. You can't really quantify it. What we've suggested, perhaps, as something that you might look at would be maybe adding in somebody who has a documented history of substance abuse or history of the commission of crimes associated with violent behavior. Again, two things that you can quantify that have shown up in studies to be at least fair predictors of behavior.
I think the problem with that is that Ms. Thompson has indicated, and others in favor of the bill have indicated, that they're concerned about a downward spiral of deterioration. And whether we agree or not, that should be sufficient to be part of the gravely disabled standard. That is what the author intends. And I think we can either impose a much stronger standard, which is not what the author intends, limited, as Mr. London says, to evidence of the commission of crimes, or listen to what the judge has indicated, which uses terms like substantial, which we often use in the law to try to set a higher bar for this. But I don't know whether that makes any difference, and I don't, again, I hesitate to get into recrafting all of these bills in committee, but we've had two, as my grandmother would have said, doozies so far.
With all due respect, there's always going to be an element of subjectivity in this. Subjectivity comes up in the area of diagnosis of mental disorder, and it comes up again in terms of grave disability.
Well, the judge has suggested substantial deterioration in perception or judgment such that the person is unable to function independently.
Arizona has a standard of, if not treated, has a substantial probability of causing the person to suffer or continue to suffer severe or abnormal mental, emotional, or physical harm that significantly impairs judgment, reason, behavior, or capacity to recognize reality. I mean, I don't know that mine is any better than that, or whether that's an improvement over mine.
I don't know what the pleasure of the committee is, and I know that there, as I said, Ms. Thompson, there are these sort of inchoate
I understand the
concerns,
dilemma, and we could
either we can say no or we can do something.
Well,
Madam Chair, may I
I
offer?
think it's very difficult to craft a definition of mental illness and severe grave disability in this arena. 9 other states, which we have before us, have various definitions that have met the constitutionality test. We'd be happy to perhaps work with Drew and you, Ms. Kuehl, and see what we could come up with in terms of a definition. We're looking at an illness, not conditions around which someone surrounds themselves. So I have to keep focused on that. It is an illness. It's not just because you've left the dirty dishes in the sink.
Well, let me trying to exert a little leadership here, indicate that the author has said that she will craft a definition of psychiatric harm that is as strong as what has been presented both in the Arizona definition by the judge or the judge's suggestion. Obviously we're not having specific language here, but there is a desire in the committee, I think, to have a definition that raises the bar on defining psychiatric harm. It will not satisfy opponents, but I don't know whether it satisfies that one concern. To use, let's say, as an example, the Arizona definition just read by the judge. So if you will take that as an author's amendment as a work in progress, work with the committee on that matter, at least that strengthens to some extent. And I'm not saying, okay, now all of you that wanted that, you're all satisfied. I don't know. But it would at least add that to the bill. I have people kind of in line, though. Ms. Bates, did you want on this?
Just to add on to that, I think it's important that it's quantifiable. I don't think the term reality is, and that we're kind of back to what psychiatric harm and in whose reality does that occur. So I think, as a work in progress, we need to be more definitive that it should be quantifiable, as Mr. Linden suggested, with some of those or expanding on those, but that you have a list of conditions that are quantifiable, measurable, in some discipline that define that. And that was an issue as it went through Health Committee also.
Well, I think as far as we can go is what we've said about this. Yeah. And unfortunately, I think we do need to get through the remaining questions, and Fisher cut bait on this. And I would like to, if you'll reserve your comments for your close, Ms. Thompson, take any further questions or comments. Ms. Jackson was next.
Thank you. I share a lot of the frustration of a lot of the people who are here today because we have a failed mental health system in the state. I think that is number one. The good judge here has acknowledged that even where we should be able to focus and achieve something on behalf of the citizens of the state, we fail to do it. We don't even have judges who care enough about this that they'd rather do probate work than deal with mental illness. And the difficulty of getting people to even accept this kind of appointment is very difficult. To get judges to even attempt to become facile and somewhat literate in the area is very difficult. Then we get back to a system where we made promises to the consumers that we were going to provide community-based care, and we provided nothing. And on the institutional side, we don't even have sufficient numbers of qualified mental health professionals to do the care when we even put people in institutions after we've made a finding of grave disability and after we've gone through all the hoops that LPS required us to go through. So on that basis, I share that frustration. I know for families, and my experience as an attorney was in dealing with families who had members who desperately needed care. And the LPS Act, in many instances, failed them as well. So my focus here today, and the reason that I have supported this bill and will continue to support it through the process, is strictly based on looking at one part of the mental health issue. That is not the community-based care portion, which we have given no shrift to whatsoever. We don't even have any community-based care programs out there of any meaningful way. When people are begging to get into programs and there aren't any to do, how can we talk about voluntary versus involuntary? I mean, we're talking here almost on an esoteric level because we don't have anything practical to provide. So in the hope that there will be some money this year, and I know that in our House there is a commitment to getting resources so that we can start a system that was promised to us 20 years ago that never came to fruition, of community-based care, both for people who voluntarily seek it and then to provide care for people who may have to start off in a system that isn't so voluntary. I mean, that really, I think, is the issue. And I know Mr. Steinberg and Ms. Aroner are focusing on the voluntary aspects. And a lot of the consumers who are here today said, look, we want to have a voluntary system. And we need a voluntary system. So my focus here, and I think what Ms. Thompson's focus was, is assuming that we need that, let's take a look at that the side of the equation where involuntary care is required. And so with that in mind, I would like to just simply urge the author, and I think with her support, to focus on the involuntary side of this system that can do the best job possible for people who need that initial involuntary introduction. And frankly, I share the concern that Ms. Bates expressed earlier about if you have a psychologist who in fact has had a patient they've decided needs the kind of care of an involuntary facility, that they shouldn't lose the opportunity to make the final decisions affecting their care and relinquish that to a psychiatrist when we don't have adequate psychiatric care even available. I mean, this is a catch-22. But to the extent that we are going to make a commitment this year to put money into a system, both voluntary and involuntary, I would like to express my support for what is, I consider, the legal aspects of this bill in dealing with, A, getting judges who are going to be required to be competent in making these decisions. You know, I don't like a bill that allows law students or other people to be making these decisions. And yet, frankly, with all due respect to my brethren and my superiors on the courts, I wouldn't have the confidence in a lot of them doing this either. And so we need to require these people to be competent in what they're doing. They're making significant life-affecting decisions. Number two, I think we need to have standards that protect the consumer and at the same time are realistic in the context that we do have people out there who are gravely disabled. We need a definition that's realistic. At the same time, we protect their rights. So I know that I've been sitting here and listening to this, and I've talked to my esteemed colleague, Mr. Steinberg, who cares very deeply about this issue as well and has a different perspective. But to the extent that we need to start addressing this issue from both perspectives, I would simply ask the author to consider what the legal system can do to accomplish the goals that are sought, protecting the rights of the consumer, and at the same time dealing with an issue that has been broken for so long that this is almost an academic discussion, and hope that we will put the funding in there to make it more of a realistic and productive discussion as we go forward.
Thank you, Ms. Jackson. Members, I'd like to take a vote on this by noon, and that's in 3 minutes. And Mr. Steinberg had asked to make one more comment. Ms. Bach has a comment. I really, this is an hour and a half now. I want this. I appreciate that members can make all the speeches they like, but I really need you to be succinct and close this off.
I will do my best, Madam Chair.
Mr. Steinberg.
It's a very important issue.
I understand.
And I'm not going to make a speech, but I have some points I would like to make, if I may. The greatest respect for the author and the work she's done in the mental health area. I agree with Mr. London. She has identified the right problem. In my view, it's the wrong solution. And I have two main problems with the bill. I know this is not the Committee on Appropriations, but $350 million, of which, as I understand it, up to 25% could be used for hospitalization. That's almost $100 million that could be spent on expensive hospitalization at a time when we're going to have a struggle this year, despite all the momentum, the positive momentum to increase funding, to get as many dollars as we can to build this dysfunctional community system. The funding priority ought to go there, not $100 million, almost $100 million towards hospitalization. Secondly, and I think most fundamentally, the bill in its policy is not placed in the context of a whole system and a continuum of care. We are all collectively fighting to build a community system in California which includes outreach to people on the street and in their homes, which includes integrated comprehensive services. The fact of the matter is, and no one will dispute this, the vast majority of people with mental illness who are out on the street or in the back bedroom are amenable to outreach and voluntary treatment. The reports from the successful AB 34 pilot project show that less than 1 in 10 of people out in the street who are approached in the right way with aggressive outreach, less than 1 in 10, will not come in for treatment, and we expect we will have a full evaluation next week. The problem is the bill makes it significantly easier to commit mentally ill people involuntarily, depending on how we end up defining grave disability. Before they can be offered outpatient commitment treatment, they have to serve 72 hours in the hospital. The problem I have here is that the bill puts involuntary commitment up front instead of at the end of the process. The bill would undoubtedly snare many people into involuntary commitment status who are readily amenable to voluntary treatment if we provide outreach and integrated services. Everyone agrees that voluntary treatment, if it's available and if people are amenable, is more effective than forced treatment. And yet, Ms. Thompson is right to focus on the families and the 5 to 10% of the people, whatever that percentage is, of people who desperately need treatment, are not amenable to treatment, and who are not in treatment. That's not a civil liberties issue to me. Those people need to be in treatment. But you have to ask the question, why are judges and counties reluctant to implement the current 5150 law in the manner which it was intended? The standard may be an issue, although we heard the judge say basically what he's trying to do through a definition is provide clarity. If the judges had the proper training, you could commit more people. I would also argue that the lack of capacity and the lack of the system drives decision-making as well. When you have a nursing shortage and hospitals that are filled to capacity, counties are not going to make the decision to involuntarily commit people, because that means they have to take them on and take on their problems. What makes sense here is to take this issue of involuntary commitment and put it into the context of the entire system. If we're going to do this right, what we ought to say that in counties where there is adequate funding, as we build this funding pot through AB 2034 and other bills, where there are counties with funding, where there is the opportunity for outreach and integrated services, and where an individual refuses that kind of approach, that kind of treatment, the 5 to 10%, only then at the end of the process do you use a different involuntary commitment standard if the current one is not working. But it does not make sense to me with all due respect, to put involuntary commitment up front and bring people into this system who would be amenable to treatment if we provided it. I urge you to consider the bill as part of the whole system, and not as just one piece which is going to fix the system, because it won't. I appreciate your time.
Thank you, Mr. Steinberg. Ms. Bach?
Thank you, Madam Chair. I know nobody wants to hear anecdotes today, but my family has been a consumer of mental health services generationally, both pre-Lanterman Petrus Short and post. And the difference is very dramatic in the quality of judgment and the quality of treatment, because what happened in the first generation was locked up and suffered permanent damage as a result. The second generation, because the first generation had that experience, the second generation was treated much more humanely. Now, the battle was to get the follow-up services. And I think that all the discussion we've had here today has shown that that's really what it's about. It's the follow-up services. Fortunately, because of LPS, the second generation was allowed to come to a self-awareness of the need for service that would not have occurred if the lockup had been extended and mandatory. And that's what I'm very concerned about in this bill, is that extension of the lockup. What is the basis for this? Why do we have to have that? Can't we let people come to a self-awareness and let them ask for services? It was a terrible battle to get the services. So I think that's what we're talking about here, is the community-based services, and we're also talking about the definitions that judges have to come to if there's anything we can do for that. But that's not here in this bill. I'm very reluctant to let this bill out of this committee in the shape it's in right now, just because of what has come up here today and all of the arguments that we've heard prior to this hearing. I have a very deep concern for the great breadth of cleanup that's needed here. And that's really my question, is what can we do about that?
Thank you. I would reserve any other statements to the author in her close, and I don't know that we have a motion on this bill yet. Is there a motion on the bill?
I'll move the bill.
Moved by Ms. Jackson.
Second.
Seconded by Mr. Knox. Ms. Thompson, you may close.
Thank you very much. I want to thank the committee for your indulgence and your endurance, and for your heartfelt wrestling with this issue. I feel a great sense of shame when I walk the streets of Sacramento or even in Yolo County, and I see people who have not accessed the system, even when services are available to them and voluntarily available to them. There are many people, and in fact, I think what we will find is that those persons who have a severe diagnosis of schizophrenia will not be able to access services as willingly and voluntarily as other persons with different kinds of disorders will be able to do. I would like to ask Colleen King to tell you a personal story, and that's how we will end our presentation. I appreciate Mr. Steinberg's comments. They are heartfelt as well. I think there is an opportunity for us to provide services in the outpatient arena, such as are presented in this bill, to provide them to patients who cannot seek them for themselves, and to deal with the issues of hospitalization in a continuum of services. I've been in this field a long time. In fact, I started washing dishes in a mental hospital at the age of 14. So I know that a hospital setting is an appropriate place for a period of time and for a particular kind of person. And we can't discount that we are going to somehow eliminate hospitals in favor of community services. That won't happen in my lifetime, and I doubt that it will happen in anyone else's lifetime. I think continuous services are very important. I've worked for those all of my adult life. We will never have consensus on the issue of involuntary care. That is pie in the sky. I knew that taking this bill, and I know that today, and I know that through the rest of this bill. There will not be consensus. There never has been on this very important public policy issue. It is very much like the other public policy issues for which we do not have consensus: abortion, death penalty, and a few others. It will not happen. So I accepted that when I took on this bill. We were told that there were some myths that we were operating under in putting this bill together. Well, 80% of those who have the diagnosis of schizophrenia today, with appropriate treatment early, recover. That is not the case when I first started psychiatric nursing in 1961. In those days, the diagnosis of schizophrenia was a death knell. And it was a terrible thing for families, and it was a terrible thing certainly for the patient. And lots of young, able, bright people ended up not being able to survive. The suicide rate among schizophrenia patients is very, very high. Crime issues, I don't sell this bill based on violence. In fact, the first time I heard anything about violence was today from one of the opponents of the bill. This is not about trying to keep people from being violent. Although other states, for example, New York, have taken action based on persons who committed violent acts because they had a history of not being treated. And I think we do need to look very carefully at that, and that's why the second part of the bill, which extended the time for those who were dangerous to others. I happen to believe that freedom is very important. I was a public health nurse in Washington, D.C. before the Martin Luther King March. I know what it means to say whites only on a bathroom door or a drinking fountain. I understand the issues for the clients very personally, and I care about those issues. This is not about either or. It's a continuum of care for people who need it, whether they need full voluntary services and they themselves access them, whether they can get the best help through self-help groups, and certainly those are very successful in many areas, or whether it is that you have to go into a hospital, be stabilized, treated against your will, medicated. And no one has sold this bill on medications being without problems, although today's medications are certainly better than what we started with in 1959. I think it's very important that all members of our society have the right to treatment. And today in California, that does not happen. And it's not just because we don't have the resources. It's because this law has been ineffectively applied. The judges, the sheriffs, the district attorneys, the whole public safety arena has turned into the safety net for the mentally ill. And we today have 20,000 mentally ill people in the state prison system, many in our county jails. And I think that is a shame on our society, a shame. I'm going to ask Colleen to close.
Ms. Thompson, I'm sorry, you've put us in a fairly awkward position because we don't allow further testimony by witnesses, which is really what this would be during the close. Close is reserved for the author, and I recognize that you were prepared to read us a story, but I honestly can't bend the rules just for this one bill. And I thank you for your earlier testimony. But the close is reserved for the author.
Colleen wanted to tell you about her brother and his experiences with the Lantern-Petrus Short Act, and how had the definition of gravely disabled been a better definition, he perhaps would have had better care. Thank you.
And thank you, Ms. King.
I would ask your support of this bill. We will continue to work with all of the interest groups as we have done.
Thank you. All debate having ceased, we'll move to a vote on the bill. Secretary, please call the roll.
Kuehl?
Aye.
Kuehl, aye. Ackerman?
Aye.
Ackerman, aye. Aaroner? Aaroner, no. Bates? Bach? No. Bach, no. Corbett? House? Jackson? Jackson, aye. Knox? Knox, aye. Longville. Longville, aye. McClintock. McClintock, no. Pacheco. Pacheco, not voting. Shelley. Steinberg. Steinberg, no. Wiggins. Wiggins, aye. House abstain.
Ms. Thompson, you have 6 votes, and we'll place that bill on call.
Thank you very much, Ms. Kuehl and members.
Now, before we break for our lunch, and Mr. Pacheco, we're awfully late. So Mr. Maddox has a witness. You have a witness. I'm sorry we can't get to it now. We have to lift the call and leave. But members, I'd like you back in room 447 at 1:30. We've done 3 out of our 19 bills. I'm going to lift the call on file item 2 before we leave. File item 2 by Ms. Romero. The vote stands at 7-2. Secretary, please call the absent members on file item 2.
Bates. Bach. Bach, aye. Corbett. House. House, no. McClintock. McClintock, no. Shelley.
All right, Ms. Romero's bill, file item 2, has 8 votes, and that bill is out. We'll reconvene in room 447 at 1:30 sharp. Ms. Migden will present a bill at 1:30 sharp briefly, then Mr. Pacheco, and then Mr. Maddox.